For the U.S. Department of Education's Office of Civil Rights. So I work to enforce civil rights statutes, meaning protections of race, sex, and disability discrimination here in Dallas. And so Texas is one of my states that I work in. I've been with mock trial for, I guess, about 5 years now. Before I was an attorney, I was a high school speech and debate coach. And so I taught high school for about 4 years in East Texas. Did things, if any of you have done debate before, like CX, LD, Extemp, all that kind of stuff, that was me. I was that coach. And so I did that before I went back to law school. I also did some mock trials. I didn't do it competitively. We did it for our school. It's kind of a demonstration thing at the end of the year. So I've kind of done mock trial, wow, I guess maybe the last 10 years or so. I've been involved with it in some way. Today what we're going to do is we are going to do a complete run through. This is a beginner session, and so I'm going to help you guys walk through all the paces of a trial. Okay, we're going to go from beginning to end using this practice problem as our guide. And so a couple of things I want to make you aware of is, one, this practice problem only has 2 attorneys and 2 witnesses. That's not typically the case. Typically, you'll have 3 attorneys and 3 witnesses in a real problem. So this is a little different in that regard. It is a criminal matter this year. This year's real problem is a criminal matter, a little different type of criminal matter, but they're both criminal cases. So in that way, when we're talking about burden of proof and criminal stuff and things like that, it's relevant and applicable to this year. So I want you to know that. We try to pick a practice problem that matches up with what we're doing in the actual season. Okay, so I'm going to put some info up here on the slides, on the projector, as we're going through. And here's kind of an overview of what we're going to be talking about today. First of all, we're going to go through the jury charge. We're going to break down the jury charge. And so this will be kind of a conversation and discussion to break it down and help us to focus on what we need to prove in today's trial. Next, we're going to talk a little bit about burdens and what that means and how you use it when it comes across. We're going to talk a little bit about defense and prosecution strategy. When I get to that part, that's really more for you to take home back when you go back to your school and you're working on this. A way to think about how to approach the real problem and where to start and kind of how to work through the problem. So I'm going to try to give you a little bit of, that way you sort of teach thyself. You kind of have a strategy on how to get started. Then we're going to talk a little bit about some of the rules of evidence, and I'm going to walk you through a couple of things like how to introduce a piece of evidence and exhibit into testimony, how you do that. We're going to talk a little bit about how to impeach someone if you know they're lying, they made it up, or they're really not being truthful to what their witness statement is, how to catch them on that. We're going to talk about that. And then we're going to do a full walkthrough of a trial, beginning to end, the whole shebang, from opening statements all the way to closing arguments. And I know that you guys are just now getting familiar with the case. It's fine. You'll be fine. We're going to do some examples. We're using this as a way of talking through and having some subject matter, but you don't need to know everything about the case, okay? That's fine. So don't feel like you're precluded from participating. So first of all, I need some volunteers. Okay? You don't know what you're volunteering for, so that could be dangerous, so yes. Hang on. We typically have in an actual trial, we will have 3 members of a jury. Those people are typically licensed practicing attorneys. If they're not an attorney, they're usually a 3rd-year law student. But they're almost always licensed practicing attorneys. They sit here in our jury box, so there'll be 3 of them. And then there'll be 1 person who is an attorney, sometimes is an actual sitting judge, like Judge Hoffman, whose chambers we're in, is a great supporter of mock trial, and he will often come and help and actually judge for us. And so you may have, when you compete, a real sitting elected judge as your presiding judge, which is great because they're amazing. They know everything about what to do. And so you're lucky when that happens. Don't be afraid. You're lucky because you have a real good expert to work with. So today, what I'm going to ask for from you is for some volunteers. I'm going to need 2 attorneys for the prosecution, 2 attorneys for the defense, and then 2 witnesses for the prosecution and 2 witnesses for the defense. So almost all of you can participate today. Actually, all of you really could participate today because may need a little bit of assistance with our judge. So, who would like to be a prosecution attorney? Okay? Then I'll get you to come sit right up here, please. Need one other prosecution attorney.
Shall I bring my papers and laptops?
Do it.
Shall I bring my laptop papers?
Yeah, you can bring everything with you. That's fine. Go ahead and grab your seat. Anyone else want to be a prosecuting attorney? You want to be a prosecuting attorney? Go ahead and grab this seat. Why am I having them sit here? So here's the first question. Why do they sit on this side?
Because they're the burden of proof.
They have the burden of proof and they need to be closest to the jury box. Good job. Good job, guys. Did y'all learn that this morning?
Yes.
Okay, good. Good. You're listening. That's great. Okay, I need 2 attorneys for the defense. Okay, you want to grab a seat here? You want to grab a seat there? Okay, so I need 2 witnesses for the prosecution. Okay, if y'all come sit here. I need 2 witnesses for the defense.
Oh, I want to be.
You what? You want to be a witness? Okay. Do you want to be a witness? Okay. You want to be a witness? Okay, so there's 3 of you. You get a choice. You either be a witness or the judge. What do you want to be? Any takers on the judge? You want to be judge? Okay. So you'd like to come sit here. If you will come and sit right up here, up at the front. We're talking, you are the judge. So what we'll need to do, I think, is go right up through here. Go ahead, grab your seat. And I'll help you out. The next one, go around there. Go grab a seat. Grab your seat. You are Judge Hoffman today. But yeah, you want to grab a seat? Just don't mess with any of this stuff, but you will be doing some of our rulings, and I'll help you through that as we get
So far away,
Okay?
so tall.
I know, right? It's intimidating. Wow.
She actually looks like a gentleman.
Okay, so we have all of our witnesses, we have all of our attorneys. So let's start talking about this problem. Okay, so I'm going to get you guys to flip over to page 4 in your packet. And I think I gave you guys a copy of one. I hope everyone has that packet. Do you have one? Yeah. We're on page 4. It's the stipulation and statement of facts, I think is why they phrased it. We're on page 4. This is the most important sentence in the packet. Okay? And it reads like this. On June 22nd, 2016, did defendant commit the offense of impersonating a foreign diplomat? What is this?
Confess.
Do what?
Confession.
Well, no, what is this statement? Who's it going to go to?
The defense.
The jury. Great. That is the statement that this group of people have to answer. Yes or no? Okay? Your success depends upon them answering yes. Your success depends on them answering no, right? But in real competition, it doesn't matter what the outcome is. It's not how you're scored. And we'll talk about how you're scored in a little while. But in a real trial, the jury charge is the most important thing that needs to be decided in the round, okay? So that's what we're talking about. Now, let's break it down. I want you to think about who the witnesses are. So you all in the back, you all represent a different witness. So I want you to think about your characters and who you are representing. And let's go through and talk about each noun or key term in this statement, okay? So, first of all, on June 22nd, 2016, which witness or witnesses could speak to the events occurring on June 22nd, 2016? Who's the most important one? Yeah. Give me their role rather than their name.
The police officer.
Police officer, great. Police officer can tell us that that happened. Now, sometimes in a problem, you will have a like police report or something like that, and so you might need to get a piece of evidence in to prove that element. But in this case, that person, they can speak from the personal knowledge. They remember that that police officer needs to say in their testimony that it happened on that time, that day. Okay, that happened that day. That the defendant is the one who did it. Now, which witness is going to be able to tell us that the defendant is the one who did this? Police officer, right? So you're going to need to have an in-court identification. That person sitting over there, or the person named such and such, is the one who did it. So we need to identify that the defendant is the one who did this. Number 3, committed the offense. What's the offense? Where does that come from? How do I know what the aspects of the offense are?
The stipulation.
It's in the stipulations. What is it? And Judge, I'm not trying to exclude you. I know you're over here by yourself, but feel free to weigh in if you know too. Okay, so what is it? What is that called that helps to identify the offense? What's it called? What is the offense? If I was looking it up in a legal document or a legal book, what would I be looking for?
Criminal?
What?
Criminal?
Yeah, well, what is it?
It
Okay, and what's that called?
Presentation.
Keep looking, keep looking. There's something out of the law that tells us what the offense is. Yeah, the code, right? The code, there will always be a section of the code in the criminal cases, and that identifies what the offense is. There, Yep, okay. There are 2 key aspects of that I want you to pay attention to. 1, that he or she had the intent to defraud. What does that mean? What does intent mean?
So knowingly do something.
Exactly. I meant to do this. Who is the person that can speak to whether they had the intent to do something? The what?
The defendant.
The defendant, exactly. So both sides are going to have to get out of the defendant what his or her intent was. Okay? You're both going to have to hit on that point. What was their intent? The other thing is obtaining a thing of value. What's the thing of value here?
Passport.
Well, that's not what he obtained on June 22nd, 2016.
The ticket.
The what? The warning. So that's an interesting question. Is getting a warning, as opposed to a ticket, a thing of value?
Because since he's posing as a diplomat, they can't go.
Well, they could have.
Well,
The officer made a choice, right? The officer chose to give him a warning instead of a ticket. He could have given him a ticket, but he didn't. So did he get a thing of value? It's a good arguable point. That's what I'm trying to highlight. Is both sides have a little bit of room to interpret what happened as to whether they got a thing of value. So you're making a good point for that side. Last thing, impersonating. I think it's the last thing. Yeah, no, two more things. Impersonating. So who's going to speak to impersonating?
the Constitution?
Well, there's actually a witness on both sides that can speak to this. Which witness, who can speak to the impersonating?
No, sir.
Not the police officer.
No, sir.
And the defendant? The secretary, assistant
The one that
secretary.
goes to the
The Secretary of State or Assistant Secretary of State on one side, that's the prosecution person. What about on the defense side?
Deputy Minister.
The what?
The Deputy Minister.
Yeah, the Deputy Minister of the Kingdom of Hawaii, right? So we've got conflicting witnesses who are arguing the point of whether this is a real or a fake position that he has, and whether it's a foreign state, whether he's actually representing a foreign, and foreign, as it says in the statute, which we're going back to, foreign government accredited by the United States. So that's a key question. Texoma doesn't recognize this, this kingdom. But they petitioned to the UN to be recognized, but we don't have any information on whether they're recognized by the United States. We also saw that Hague, the International Court, has recognized this entity. So that's a good question. Do we have a foreign diplomat that's involved? Okay, and so those two witnesses have conflicting testimony on these points. So what I want you to see from this, in this one sentence, we have broken down every witness in this trial and identified the key facts that each witness needs to bring about, and the points in which we have conflict. We have conflict over this concept of intent or thing of value. We have conflict over impersonating and foreign, right? We don't really have conflict over the date, and we don't really have conflict over the defendant, but those still need to come out by the prosecution side because they have to prove these. So they have to make sure those questions get asked. But this is the jury charge. This sentence goes to the jury. They must say yes or no, this is true. All of those things have to be there for them to be able to say yes. So let's talk about burdens. What kind of trial is this? Criminal trial. So what's our burden? It's what? It's what?
Just like the
Okay, burden on this one is beyond a reasonable doubt. Okay, there are three different kinds of burdens: beyond a reasonable doubt, clear and convincing evidence, and preponderance of the evidence. Typically, the only two you see in mock trial are in civil trials. You'll see preponderance of the evidence. That's usually like a lawsuit. Someone's suing someone. They got hurt, they got injured, their property was destroyed. They want money, whatever. That's a civil trial. That's not what we were doing this year, but it is what we did last year. This year, our burden is beyond a reasonable doubt. Now, what does that mean?
You have to sort of show that the person committed the offense.
That they committed the offense?
Well, in our case, that they did not commit the offense.
Well, do I have to show you that they did or did not commit the offense? No. What do I have to show you if you're my jury? Yes, sir.
Hawaii is a kingdom.
A what?
Hawaii is a kingdom.
Well, no. We're talking about on the ultimate issue. So we're talking about the ultimate issue. What do I need to show you?
Did he
That he impersonated a foreign diplomat.
No, not whether he did or didn't. That's not the requirement.
No, if he was considered foreign diplomat.
Nope. Still no.
Did they commit the offense impersonating a foreign diplomat?
Look at page number 3. Yeah, number 3 of the Statement of Stipulated Facts, second paragraph, first sentence. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. Now look at the next paragraph. A reasonable doubt is a doubt based on reason and common sense after a careful and impartial consideration of all the evidence in the case. It's the kind of doubt that would make a reasonable person hesitate to act on the most important of his affairs. So what that means is not that I must prove that he did or did not do this. I must prove to this jury that no reasonable person would think that he didn't do it. No, okay? And failing that, if there's any reasonable doubt as to whether he did this, then you win, right? So they must prove that there is no reasonable doubt that he didn't intentionally impersonate this person for the purpose of getting this kind of thing of value, this warning. Okay? There's no reasonable doubt in my mind. I would act on it with pretty good certainty as if I was acting on something important in my own life, right? So that's the standard. I don't have to show and prove beyond all doubt that this happened. There can be some doubt, it just can't be reasonable. Okay? If there is reasonable doubt, you guys win. And so the burden is in your favor. They have a high standard in which they have to prove. So, witness testimony. There are two different kinds of witnesses. There are eyewitnesses, and then there are expert witnesses. Eyewitnesses, they have no facts, they know details. They were present or they have information. Expert witnesses are doctors. They are engineers. They are technical experts, psychologists, psychiatrists. that are able to render a professional opinion. In high school mock trial, we virtually never use expert witnesses, okay? So no one should be really giving an expert opinion on anything in this trial. Now you have two people, Under Secretary of State, and then you have your Foreign Minister of the Kingdom of Hawaii, that they have important titles, but they're not expert witnesses, okay? They can give factual information about the trial, they can, about what they know, in their positions as their role, they can give us some factual information, but they don't get to tell us an opinion as an expert, okay? And there's not sufficient information in there to prove a person as an expert. So I just want to make that clear, because some students try to do expert testimony, and it's usually there's not enough there to get to that level. So just keep that in mind. Okay, so plaintiff strategy. If you're the plaintiff team, and this is what I encourage you to do, like I said before, whenever you go back to your school and you're working on the problem for this year, I encourage you to kind of think about the problem in this way. So I would encourage you to take like a week or two and block out and everyone be just the plaintiff team. We're just going to work on the plaintiff side of the argument. Okay, that's what we're going to focus on for this block of time. And we're going to go through the problem over and over again. We're going to identify every factual piece of information that we need to make sure it gets out. Maybe take a highlighter and highlight. This is a key fact. It answers the question in the jury charge. This is a key fact. It answers a question in the jury charge, right? And what are relevant exhibits? Are there any exhibits that are important and we must get out? The jury needs to see this. It's important. It's going to help them make their decision. Is there any testimony that is in that statement that I don't want to have out? Okay, is there any testimony in there that I could keep out from being brought out by the other side? Anything I can object to? So you just kind of want to go through all the witness statements, go through the problem packet, and identify those key aspects. And then I encourage you to kind of think through, as a plaintiff attorney, what are all of the positive things I can get Kim Hopart to say on the stand? What are the things I need them to say that are going to help me prove my side? Okay? And then what are the positive things that Jan and Dean could say that I really need them to bring out on my side as the prosecution? Oh, I guess I said plaintiff, sorry, prosecution. And then I also want to think, well, what are the negative things that the other side might want to bring out about this witness? Whenever they cross-examine, they're going to have a chance to ask questions of my witness as the prosecution. Well, what are they going to do? What are they going to try to get out of my witness that would be bad? Okay, I want to think about this. What are the things, the other witness, that are going to be bad? So you want to really kind of think through, what am I going to do, and what's the other side going to do? Do it on their witnesses. You think about, well, what negative things are they going to bring out on their witnesses? And then what positive things could I get out of their witnesses when I get to ask questions? So you want to really kind of break it apart. What's good, what's bad, kind of separate those key aspects out. Do the exact same thing, then take some time and go through and think, oh, out of all of this information, what's the theme of my case? Well, what is the message I want the jury to take away? For example, if I'm on the prosecution side, this was willful and intentional attempt to deceive a police officer. Willful and intentional attempt to deceive a police officer. That's what this was, nothing more, nothing less. That was what he was trying to do. He was trying to impersonate a diplomat and confuse police officers so that he could get off. If I'm over here on the defense side, and I'm thinking about what my theme is going to be, it's like, he really believes that he is a foreign minister. He paid for it. He got his credentials. He really believes that he is this person. He didn't do anything malicious or intentionally. He was honest and upfront. That's what he was. He was honest and upfront, whereas he was malicious and deceptive. Okay, so that's sort of my theme. It's the core thing I want the jury to believe on my side of the issue. So we've done the plaintiff. On the defense, you do the exact same thing. take a week or two, working through the problem, break it apart. Identify the facts, the exhibits, think from the defense perspective. Think about all of the witnesses. What are the positive things I can get out of my witnesses? What are the negative things the other side's going to get out of my witnesses? Think about their witnesses. What are the negative things they're going to say? What are the positive things I can get on my side? What's the theme of my case? What am I trying as the defense to get across? So really try to break it down as best you can. Once you've identified those pieces, your questions are really pretty simple because you've identified all the things that you need to get out, and you write those in the form of a question. So let's talk about how we actually do a trial. So in a trial, we start out with some opening statements. Each side gets 5 minutes to do their opening statements. When you do your opening statements, you are going to, at the very beginning of the trial, the judge will ask each side if they are ready to proceed. So, Your Honor, why don't you start out with the prosecution side and ask them if they're ready to proceed. And just say that. Prosecution, are you ready to proceed?
Prosecution, are you ready to
And whenever you are answering your judge, what must you do?
Your Honor.
Do what?
Your Honor.
Well, one more important thing.
Stand up.
Stand up. Okay, so who's going to answer for, well, actually, you should both stand up if you're responding to this. So, who's going to answer?
Yes, Your Honor.
Okay, great. And then?
Prosecution, are you ready to proceed?
Oh, they've already done that, so now we're going to go to, defense. Okay?
Are you ready to proceed?
Yes, Your Honor.
Okay, and once you've answered, you can have a seat. Sorry. Okay, so both sides are ready to proceed. Now, we're going to do opening statements. So, you want to call for opening statements for the prosecution?
Prosecution, call for openings.
Okay.
Do you wish to make an opening statement?
Who wants to do our opening statement?
Nominated.
It's only going to be like 30 seconds. It's okay. It's okay. Just one of them. And then just say you may proceed.
You may proceed.
Okay, so what you're going to do is you're then going to speak to your jury members.
Yes.
Okay, so if you want to come over here. Well, let's practice that walk again. Okay, so let's go back and let's practice that walk. Now, one thing, and this can be strategic. Sometimes you might want to walk around over here. Okay, depending on how your courtroom is laid out, it's a little tight, but you may want to walk around so that you're a little further away starting off. But anyway, if you want to go ahead and come around, and you're going to face who? Okay. I know, it feels awkward. That's why I want, so you're facing this jury, so if I'm going to be a jury member right here, okay? So you're speaking to me. Now, what is he going to do in his opening statement? What's the purpose of an opening statement?
Just to like a summary.
Set up what you're going to prove.
Yeah, you're previewing for me what I'm about to hear. Okay? So some of the things that you want to talk about is what the witnesses are going to speak to. What are the witnesses going to say? What am I going to hear? What's the story? So why don't you give me just, summarize for me, what are your witnesses going to talk about?
I have to remember everything.
Okay, well you have a police officer, right? So what's the police officer going to tell me?
Police officer will tell you about how he encountered the diplomat and
Okay.
how he has to how he chose to give him a warning about the ticket.
Okay, okay. Great. I mean, you're doing good. You're doing good. So today you're going to hear from Officer whoever.
Yes.
Officer whoever is going to tell you how the defendant presented these fake diplomatic papers in order so that he would only get a warning instead of an actual ticket. Okay? And then who else am I going to hear from?
Kim will probably like the Secretary of State of Solo to present like how there's no way to prove that the Hawaiian Kingdom is not a real kingdom, not a real thing.
there's no way to prove that it isn't a real thing, or it is?
It's not real.
Okay, yeah, so today you're gonna hear from the Assistant Undersecretary of State, or whoever, whatever her title is, and she's going to speak to how this passport was clearly fake, that there is no Kingdom of Hawaii, that this entity does not exist, right? And so you're just summarizing for your jury members what we're gonna hear. And you're also gonna talk about burden of proof, that yes, you have this burden of proof, but it's not an unreasonable burden of proof. It is just that at the end of today, you shouldn't have any real reasonable doubt as to what happened. And that's a standard that courts, that are met in courts all across the country every single day. It's not an unreachable standard. It's a higher standard, but it's not an unreachable standard, and courts see that standard met every single day, right? So you're just softening that burden.
Yes.
Right? Okay, so he's doing that opening statement. Okay, so you're good. You finished your opening statement. Yeah, you can go have a seat. And then, who are we going to hear from next? Okay. Okay, so we're going to, what did you ask him? Yeah, you got it. Yeah. Yeah, do you have an opening statement?
Do you have an opening statement?
Okay, can you proceed? Okay, great. So you're going to come up, and then what are you going to do in doing your opening statement?
To try to explain, or try to get my witnesses to explain why my client believes that he did not commit a crime.
Okay, great. So that's sort of your theme, is like his belief, right? So you're going to talk a little bit about your theme of your case. You're going to talk about your witnesses. So let's talk about each witness. So let's talk about the foreign minister first. Okay. So what's the foreign minister going to tell me today?
She's going to try to explain how Hawaii thinks of their status as an entity.
You got it. Yeah. Okay. So today we're going to hear from the foreign minister of the Kingdom of Hawaii, and that foreign minister is going to speak to their status as a sovereign country, right? And then who else are we going to hear from today?
From Mr. Wong,
Okay. Who is
my client, which is the ambassador of the Kingdom of Hawaii.
Okay, and he's the defendant in this case, right? So we're going to hear from the defendant in this case,
Yes.
who is an ambassador for the Kingdom of Hawaii, right? That's great. I like how you did that. That's good. And so we're going to hear from her, and she is going to speak to what? What is she going to tell me about beyond that she's an ambassador? What else is she going to talk to?
She's going to explain how she got her passport, everything, her reasoning on why she was going at such a high speed.
Okay. So she's going to give her side that, that she didn't believe she was speeding, but even more to the point that she is an actual official, that she paid her money